So welcome back, teams. Great to see everyone back together again for the Property Powerhouse Podcast, latest episode. Welcome back, landlords, friends and family, all of our partners. Thanks for all the support up to now. It's had some really good feedback. So
yeah, absolutely.
We're all really pleased with how it's going. Particularly the little clips, I think, quite impactful. So that's been great. So today we're talking about the Renters' Rights Bill.
Yeah.
And Bex and Leah, I know that you and your team are having to keep very up to date with all of the constant changes and the ping-ponging and the toing and throwing.
Yeah.
So I think it'd be useful today for you guys to give a bit of an overview in terms of, let's go back to basics, because some people watching the podcast might not even know what the Renters' Rights Bill is. Very unlikely, but some people may not. So it'd be good just to give a bit of basic background, and then just to get your thoughts on, the recent changes, impact for landlords, and what landlords need to really be thinking about, what needs to be front of mind in terms of compliance, protecting themselves, their assets, their income, and so on. So Leah, Bex, what is the Renters' Rights Bill?
So it's primarily focused on just giving tenants that extra security when they're renting privately in England.
Yeah, so it was initially the Renters Reform Bill, which was introduced around May 23, and then when the new government took over in around September 24, it was reintroduced as the Renters Rights Bill, so that's what we know it as now. So those are sort of the updates that we've been following over the last, 12 months. I know it's a hot topic at the moment, there's lots of changes, lots of updates. So hopefully today we'll be able to give landlords and agents a bit more insight into the key provisions and what's changing.
And I think maybe the change in name, calling it the Renters' Rights Bill, maybe the government saw that as reflecting more what they were trying to achieve.
Yeah, definitely.
Yeah, absolutely.
Do you think that in terms of the name?
Yeah, I think initially probably a lot of landlords and agents were sort of scared of the bill, but we've had a lot of time now to look at the changes, and actually in most cases, if you are a compliant landlord and a compliant agent, and you're keeping up to date with everything, you've got everything in order for these changes, then really you don't have anything to worry about.
Yeah, and I think your agents are constantly contacting you. I mean, you're keeping them up to date, aren't you?
Yeah, we are. I mean, in both ways, really, in terms of the way our workflow will look as well. Obviously, we're doing so much in the background preparing us, but as we all know, we're waiting for that green light, let's say, before we know we have to implement, whatever. As we've touched on, I think the main thing is the agreements, how that's going to look. Assured periodics, no fixed terms, rent increases once a year. So agents, you're exactly right. I think we're a little bit concerned at first, but as now more knowledge is coming about for the bill, I think they're feeling a lot more confident.
Yeah,
definitely.
I think we're all sort of getting our heads around it, aren't we, and how it will impact on our processes. So if we go through the main changes maybe one by one, and then Bexley, if you could tell us maybe just a few lines about how each change will affect landlords and agents.
Yeah. So I think the first change is the Section 21 being abolished. So a lot of landlords now rely on Section 21 notices. So I think when that was initially announced, again, landlords were scared, landlords were exiting the market.
Definitely.
But when you actually look into why landlords serve a Section 21, it's typically when they want to sell the property or if they want to move back into the property. So we will go into it a little bit more detail later on, but there will be grounds added to a Section 8 notice whereby if you want to sell the property or if you want to move back in, that will be relevant to you.
Yeah. So I think there was a lot of scaremongering at first, wasn't there, about the abolishment of Section 21s, but I think that seems to have settled down a bit now.
Yeah,
absolutely.
Definitely.
Yeah.
I think now we've got more clarity on what's actually coming into place, what grounds we're looking at. I think it is a lot less scary instead of just saying it's gone. You can't evict your tenants. You can't have your property back.
Yeah. So the second change
is that you'll be looking at no fixed term tenancies. They're all going into a periodic stage.
Yeah.
And that is probably one of the biggest changes alongside the abolishment of the Section 21.
Yeah, so assured short hold tenancies will be no longer.
So just rolling periodic for everything.
Exactly,
Yes.
yeah.
And in terms of notice periods then, landlord to tenant, tenant to landlord, what will that be moving forward?
So it will differ. So landlords will be expected to rely on a Section 8 notice, and the notice periods will differ based on the grounds that you're relying on. So
Fine.
similar to now,
Yeah.
but they'll have set grounds for the new grounds.
And
Set notice periods for the new grounds.
Section 8.
Yeah, so as we touched on, so there'll be new mandatory grounds added, so grounds 1 and 1A, and they will be mandatory. So as long as a landlord can prove those grounds, then if a landlord has to go to court, there should really be no reason why possession would not be granted.
Okay, so actually it's really helpful for you, Bex and Leah, to break it down, because actually when you explain it in more detail, it's not quite as scary as the press would make it out to be.
Exactly. I mean, we deal in the eviction side, so we're dealing with landlords and agents all the time, and especially for serving notice, as I said earlier, Section 21 is for selling or moving in, and then you've got a Section 8, and I would say 90% of the Section 8s we served are rent arrears, and so, when the Section 21 goes, the Section 8 will have all of those grounds there. Yeah. So as long as you're a compliant landlord and you've got evidence of those grounds, really you should have no problem in terms of gaining possession. Yeah,
I think that's a really important point, isn't it? And I know that your team, Bex, are on hand and have been for the last few months with landlords, helping them with their compliance audits. Yeah. So I think one of the messages that's going to come through for the whole of this podcast is you need to be on top of your compliance. Yeah, and if you've got any doubts, if you're an agent, pick the phone up to Rom, run it past Rom, and then if you're a landlord, to pick the phone up to one of your team, Bex, and just to see what they need to do to make sure that they're compliant and ready to go.
Yeah, absolutely.
So the next one, which some landlords may be a bit concerned about.
Yeah, that would be the rent and increase limits, and then the bidding war limits. Yeah. So essentially only being able to increase the rent once a year per property, and then also stopping bidding wars on putting rent above the market rate. Yeah. A lot of landlords are concerned about that one, but it is just there to protect tenants even more if they are privately renting.
Yeah, I think, Rom and Bex, I think we've talked about this, that I think when a property's marketed as well, that the agent will need to keep records of comparables. So if ever we do need to take it to court to gain possession, then we will need to demonstrate that it was marketed at the current market value. So, I presume your agents have got some steps in place to build in that process. But
yeah, exactly. That's because I think what naturally the first question that or assumption, let's say, is, well, that initial market value is just going to skyrocket. Yeah. That's what people expected. Yeah. And then in a sort of a flip it on its head way, that the bidding war may be trying to get the rent lower, which obviously never was a thing. Tenants would happily offer more just to try and secure the property. But it's exactly that. So now there's comparables, which the systems that agents have in place to be able to provide those comparables, they're all getting ready for that, and so are we on the back end, we're linking in with Property side of things, where we can work with our agents on that.
Yeah, had a really interesting meeting actually with a build to rent really huge agent in London a couple of weeks ago, and he was saying that this is going to be really interesting, where they have blocks within an area where the value of the rent is actually higher than the rest of the area around it, so they're going to have to make sure that they're on top of proving that at the time. So it's going to be some interesting anomalies within that. So yeah, but agents, landlords, if you've got any concerns, obviously again just pick the phone up to us. And the last one that we'll touch on today.
Yep. So pets. So going forward, landlords will not be able to refuse pets unless there is a reason. So for example, if they were in an apartment with no garden, then they have the potential to reject a pet, but as standard there will be a blanket ban on rejecting pets.
Yeah, and I think because of that anticipated change, we're working with our insurers, aren't we, Rom, in terms of a number of new insurance products for landlords and tenants against pet damage. Yeah. So again, if anyone's got any concerns or any queries about insurance to cover them, then just pick the phone up and give us a ring. So I like this ping pong stage. So where are we exactly now? Because there just seems to be lots of confusion, even when you read different newspapers.
It's hard to keep up because there's
up.
multiple newsletters going about. You know, we attend all the conferences, but we are now at the late stages of the ping pong. So
the final serve.
Yeah. So the next update is on the 14th of October.
Exactly, and that is where it's going to go back to the House of Lords to essentially assess the amendments made by the House of Commons. We'll get their thoughts from there, and then hopefully it can progress even further.
Yeah, so then we'll get to probably late 25 Royal Assent, and that's when the bill will be be made an act. So it's anticipated that we're looking at early 2026.
Exactly, around April 2026.
Yeah, so a phased approach.
Yeah, staggered approach from there, really.
So Q2.
Exactly.
Yeah, so it's not going to be a case of it's an act, all of these changes are going to happen overnight. It will be over a couple of months. So I think the first one will probably be the Section 21, but there'll be an implementation date for that.
That makes sense. So at least the end is in sight.
Yeah.
At last.
Yes.
At last.
How long's it been going on for now?
So with the actual bill, so it'll be a year.
A year.
Yeah. With the Renters' Rights Bill, since obviously that was taken over, so a long time, and there's been a lot of uncertainty.
So threshold for rent arrears, that's going to
so at
change.
the moment you have to have 2 months rent arrears and you'll be looking at a 2-week notice. However, when this comes into place, we're expecting for it to be 3 months rent arrears.
Yeah,
with
and
around 4 weeks notice
period. This is hard to get our head around at the moment because we've gone so long with the current notice periods and the threshold. Obviously that's all going to change, but it means again landlords will have to give a slightly longer notice period, wait to serve that notice for the rent arrears to be 3 months. So we anticipate that there'll be a lot more mediation. Because obviously courts are, the court system is completely backlogged no matter where you are in the country at the moment. So if landlords are going to have to wait longer to serve the notice and then to actually go to court, the likelihood is more mediation, will be in place.
So Ram, I know we're going to talk about this in one of the later episodes, but for me, this extended rent arrears situation and notice and so on, it's going to take longer to gain possession. So we're going to talk about rent protection and legal expenses cover. I mean, your agents must be thinking, wow, this is a no-brainer really for them and their tenants.
Definitely. It's always been, a really vital product, but it's never had the uptake that you'd probably expect really. It's not really been, we know from our sort of agency days, let's say, that it's not really something that was at the forefront of your mind, really. Something that always just ticked along, whereas now, agents I'm speaking to, it's their key focus more than anything. It's now becoming a part of their initial offering when offering a landlord a service, whether that let only to managed, it's letting a property without really an option of without rent and legal protection. We touched on landlords, yes, they have become a bit scared in an initial instance because of the bill, but together with having a managing agent there for you with all these changes, but rent and legal protection, as simple as it sounds, really is the answer. So
100%, and I think agents probably will share our view when we're talking to landlords as well, that we have a duty of care, and agents I know take this very seriously to talk to their landlords about this product, because why would you not take it out now? There's going to be a protracted period of time to gain possession. So,
and I think it's to do it now as well. As we say, we're expecting April, yes, Q2, we've got a bit of time, but it's not really, it's look how quick time goes anyway, but it's a matter of doing it now. We're only 6 months away. Get ahead of the curve and do it now, because if we were taking a bet, a lot of landlords who are considering coming out of the market, once they get that date for Section 21 notices, they'll be going, okay, I'm going to do it now. I'm going to get out of the market now. So if you put the solutions in place now as an agent, give your landlords the confidence to stay in the market, certainly the time to do it now.
And not only that, it's something we're going to touch on in a later episode, but the pricing as well. If a landlord waits until April, May next year to take this product out, we're going to see significant price increases between now and then, I'm sure. So all agents, speak to Ron.
Speak to me.
If it's not something that's in your armoury of products and services, then it needs to be there now. So Bex and Leah, so new mandatory grounds, talk to us about them, what that means.
Yeah, so we covered them earlier. So the grounds 1 will be for when a landlord wants to sell the property, and then 1A will be when they are moving back into the property or immediate family moving into the property. So they will be a 4-month notice period. If you have used those grounds and the tenant's vacated, then you can't re-let the property for 12 months from the date that the tenant's vacated.
Right, okay.
So that's to avoid false evictions, basically, landlords misusing grounds.
I'm quite interested in how some of these are going to be policed.
Yeah.
Yeah.
You don't need to
That's
answer.
a lot of landlords and agents are probably thinking the same, as are we.
Yeah, it's going to be interesting to see it all unfold,
Yeah.
isn't it? Great. So the waiting period before a landlord can relet, so you've covered that. So that's going to be actually quite a long time.
Yeah,
Yeah.
exactly. So don't take the risk.
Don't take the risk. I think
No.
that's the message, isn't
Yeah.
it?
Yeah.
Genuine grounds only.
Yes.
Yeah, definitely.
If anyone's in doubt, just pick the phone up
Yeah.
Yeah.
and you'll talk to them about the sensible grounds to
Yeah.
use. So rent increases,
Yeah.
frequency.
So you're only looking at now doing it once a year, so 1 rent increase per property at the moment.
Yeah.
Okay. Probably not actually. I think we've mentioned this one. That's actually not that different, really, is it?
It's the
From
same. Yeah, it's the same now.
Yeah.
I think it's just changing, as an agent standpoint, it's changing your internal workflow
Yeah.
a bit of a behaviour change, because what you'd come across is every 12 months, or if it was a longer fixed term tenancy, at that point you'd have a renewal or a
Yeah.
renewal conversation.
Yeah.
Whereas now I think renewal is going to be replaced with a rent review,
Yes.
together with what we saw in May with the sanction checks. I think around that time it's good for agents to now build in a workflow of saying, okay, I'm going to do a rent review, maybe check all compliance, just gather something at a point of where you're not doing a renewal, you're checking your sanctions, your compliance, and doing a rent review, and that becomes your renewal process internally, rather than issuing a new agreement, of course, because as we know, it's not needed.
No. Okay, brilliant. So we'll work with all of our agents, I presume, with new documentation that they need.
Certainly, yeah.
And we offer the Section 13 notices as a service. We do that now, and of course we will continue to that going forward. So what I would say to landlords and agents is to familiarise yourself with those notices. At the moment, landlords and agents will just serve a rent increase letter. Going forward, it needs to be the formal prescribed form.
Yeah, amazing. And Rom, so those agents of ours that are using the Property Online free tenancy platform,
Yeah.
then those notices can be automated through that platform,
Yeah, exactly.
which quite a few of our agents are using and finding that really helpful, aren't they?
Yeah.
If I'm a landlord and I want to increase my rents, which I do obviously try and do each year, and my tenants want to challenge that, what's the process then? What's going to happen?
So what they'll essentially have to do is they'll have to go to a first tier tribunal with essentially evidence that they believe is excessively above the market rate, and essentially that first tier tribunal will essentially assess that against their evidence, against the tenant's dispute, and they will then make their assessment from there whether or not it was an appropriate rent increase.
How long's all this going to take, do you think? Wild guess. Months?
Yeah.
A piece of string, yeah.
I don't think it'll be quick at all.
No.
And I think landlords, again, it's not worth taking the risk of putting the rent up above market rate, because these tenants, if they do, take it further to the first tier tribunal, they're going to have a strong case.
Yeah.
And, the likelihood is the landlord's then going to be essentially out of pocket. So definitely do your research, use a managing agent and make sure that you are advertising the rent at the market rate.
Yeah, absolutely. And that's another reason, isn't it, for the fully managed service, because agents will be holding landlords' hands through that process, won't they?
Yeah,
Definitely.
they'll be well informed, won't they, of the area.
Yeah.
Yeah.
And as much as we talk about the automation through Properly of serving notices, there's also that personal touch as well. So I think that's what we always encourage landlords and managing agents. Managing agent will have that. It shouldn't become a negotiation and a race to the bottom, but it's what managing agents are there to do. They will talk with your tenants to find maybe a middle ground if it's needed.
Yeah.
Sometimes that's a good view to take rather than just going through tribunal and it taking time. I don't know, you may be able to correct me, but something we're waiting confirmation on, but if they're taking it to tribunal, I assume throughout the period of it's at tribunal is that the tenant will still continue to pay their original rent. They won't be required to pay that increased rent.
Exactly.
Exactly, yeah.
So you're shooting yourself in the foot really if you're a landlord trying to really increase it really high.
Yeah, I think that's a really good point, that using a managing agent. I think it's always good to have an objective party who's doing the negotiation, exactly like we do the mediation service when we've got a dispute between a tenant and landlord. It's always good for both parties to step back and let somebody who's got no emotional attachment to the case to come to a conclusion. Can a landlord impose a no pets clause?
They won't be able to because
any size of pet.
It really does depend on on the circumstances. There will be a blanket rule
or behaviour of pet.
Yeah. But there will
Mag's talking from experience.
I know, yeah.
2 Rottweilers in a flat.
But there would be a blanket rule where a landlord can't oppose a tenant having a pet. If it is something such as a 32nd floor apartment with, you know, a Rottweiler in there with no garden, potentially you could say that isn't really fit for purpose.
Yeah.
But as a typical rule, you can't say no pets, can you?
No, exactly. And that will be similar with regards to not accepting tenants on benefits or children. There will be a ban, and landlord will need a good reason not to accept those type of applicants.
Okay, that's really, really helpful. So that's been really useful, a useful overview, useful summary of where we are at the moment. So more to come on the 14th.
Yeah,
Yes.
definitely.
Then hopefully we'll have some more definitive timescales and decisions about what's actually going to happen. So that's going to be great.
Mm-hmm.
And we'll probably, after that date, we'll do another update.
Yeah, I think at that point we'll have, like you say, a more definitive answer. We'll have dates in place, and we'll actually know when
There'll be a lot more clarity, won't there?
exactly when all these changes are happening.
So for me, I've just taken some summary takeaway points. The first one being to keep in touch. So if you're an agent, keep in touch with Rom.
Yeah.
If you've got any concerns about what's next and what you need to do to help and support your landlords, keep in touch. And Bex and Leah, keep in touch if you're a landlord and you can advise on what to do to be prepared. And the second one is to be prepared.
Definitely.
So in terms of compliance, insurance products, you know, make sure that you stay in touch with us, and we'll advise you on what's the best way forward. So just pick up the phone to Bex, Leah, or to Romario, and we'll put contact details on at the end of this so that you know who to either phone or to email. So thank you, everybody.
Thank you very much.
That's been really helpful. And thank you very much.